The day a felony conviction hits your record, a lot more changes than most people realize. Jobs get harder to land. Housing gets harder to secure. And for many people, one of the biggest shocks comes later, when they try to buy a firearm and get denied in seconds. Let me ask you something directly. Do you believe a convicted felon can ever legally own a gun again in the United States? I want you to put your answer in the comments, yes or no. And if you think the answer is yes, explain how. Because this is one of the most misunderstood areas of federal firearms law. And what people hear on the street is often very different from what the law actually says. Stay with me, because there are layers here that most people never dig into. First, we have to start with federal law. Under 18 U.S.C. per 922G, anyone convicted of a crime punishable by more than 1 year in prison is prohibited from possessing firearms or ammunition. Notice the wording carefully. It doesn't say served more than a year. It says punishable by. That means even if someone received probation or only served a few months, if the offense carried a potential sentence over 1 year, it generally counts. That federal prohibition is serious. It applies nationwide. It does not expire automatically. There is no built-in waiting period. There is no 10 years and you're good. For most felons, the ban is effectively indefinite. And here's the part many people don't realize. The prohibition is not just about buying a gun. It's about possession. That means touching, holding, storing, or even having constructive possession can be enough. If a firearm is found in your home and prosecutors can argue you had control over it, that can trigger federal charges. Now, can that prohibition ever be lifted? The short answer is yes, but not easily, and not in most cases. Federal law technically provides a pathway called relief from disabilities, where a person can apply to have their firearm rights restored. The problem is Congress has not funded that program for decades. Practically speaking, that federal administrative path does not function. So where does that leave people? It leaves them looking at 3 primary possibilities: a full pardon, expungement or set aside under state law, or restoration of civil rights in a way that satisfies federal law. Let's unpack those carefully. A presidential pardon for a federal conviction can restore firearm rights. But let's be honest, presidential pardons are rare. They are discretionary. They often take years to process. And approval is far from guaranteed. If the conviction was under state law, a governor's pardon may restore rights depending on how the state structures it. But here's where things get tricky. Federal law looks at how the state treats the conviction. If the state fully restores civil rights, including the right to possess firearms, and does not expressly restrict firearms afterward, then the federal prohibition may no longer apply. That's a big may. Federal courts analyze whether 3 core civil rights were restored: the right to vote, the right to serve on a jury, and the right to hold public office. If those are restored and the state does not continue to restrict firearm possession, the person might no longer be federally prohibited. But every state is different. Some automatically restore certain rights after completion of a sentence. Others require a separate application process. Some restore voting rights, but not firearm rights. And if the state restoration document says firearms remain prohibited, then the federal ban remains. Expungement is another misunderstood concept. If a conviction is truly expunged or set aside under state law, meaning it is treated as if it never occurred for most legal purposes, then federal law may no longer consider it a disqualifying conviction. But not all expungements are equal. Some seal records without actually vacating the conviction. Federal authorities look at the substance, not just the label. Now let's address something uncomfortable. Some people assume that if their state allows them to possess a firearm again, they are automatically clear under federal law. That is not always true. You can be compliant under state law and still violate federal law if the restoration does not meet federal standards. And federal prosecution is not theoretical. Being a felon in possession of a firearm under federal law can carry up to 10 years in prison. In some cases, under the Armed Career Criminal Act, penalties can be significantly enhanced if the person has certain prior violent felonies or serious drug offenses. This is not a paperwork violation. This is a major federal felony. Now let's talk about nonviolent felonies. People often ask, what if it was just a white-collar crime? Federal law does not distinguish between violent and nonviolent felonies for the basic possession ban, fraud, tax offenses, drug felonies, violent crimes. If the offense was punishable by more than a year, the prohibition generally applies. There is one limited exception worth mentioning. Certain business-related offenses classified as antitrust violations, unfair trade practices, restraints of trade, or similar offenses are excluded. But those are narrow categories. For the vast majority of felonies, the ban applies. Another area of confusion involves old convictions. People sometimes believe that if the conviction was decades ago, it no longer counts. That is not how federal law works. Age of conviction does not erase the prohibition. Unless rights are formally restored or the conviction is overturned, the ban remains. Now let's talk about domestic violence misdemeanors, because this surprises people too. Even a misdemeanor conviction for domestic violence can trigger a lifetime federal firearm prohibition. It doesn't have to be a felony. If the offense involved the use or attempted use of physical force against a qualifying domestic partner, the ban can apply permanently unless rights are restored. So what should someone with a felony conviction actually do if they want to explore restoring their firearm rights? First, they need to obtain certified copies of their conviction records. Not assumptions, not memory. Actual documentation. Second, they need to analyze whether their civil rights have been restored under state law. Third, and this is critical, they should consult a knowledgeable attorney who understands both state restoration mechanisms and federal firearm law. This is not an area for guesswork. I've seen people rely on advice from friends, gun store employees, or internet forums. That is dangerous. If you attempt to purchase a firearm through a licensed dealer and falsely answer the background check form, that itself is a separate federal felony. Lying on the ATF Form 4473 can carry up to 10 years in prison. Even constructive possession can create problems. Let's say a felon lives in a house where a spouse legally owns firearms. If those firearms are accessible to the felon, prosecutors may argue unlawful possession. Courts look at control and access. Safe storage practices matter significantly in those situations. There's also the issue of antique firearms and black powder guns. Under federal law, certain antique firearms are not classified as firearms for purposes of the federal prohibition. However, state laws may differ, and relying on technical distinctions without fully understanding them can create legal exposure. Here's the deeper reality. The federal firearm prohibition for felons is designed to be broad and durable. It is not something that fades with time. It requires formal legal action to undo. And I want to emphasize something else. Even if rights are restored, documentation matters. If law enforcement questions you, you need clear proof of restoration. If you attempt to purchase a firearm, the background check system must reflect that restoration accurately. Administrative errors happen. Records can be incomplete. So let me circle back to the original question. Can a felon ever own a gun again? Yes, in limited circumstances, through formal legal restoration, expungement, or other mechanisms that satisfy both state and federal law. But for most people with felony convictions, unless they actively pursue and obtain that relief, the federal prohibition remains in place indefinitely. And here's what I want you thinking about. This area of law is unforgiving. Good intentions do not matter. I thought my rights were restored is not a defense that automatically protects you. The system expects you to know your legal status before you touch a firearm. If you or someone you know has a felony conviction and is even considering firearm ownership, the safest path is not assumption. It's verification. Because the consequences of getting it wrong are not small fines or minor citations. They are federal charges that can put someone right back into the system they worked hard to leave. That's the gravity of it. And it's why understanding the difference between rumor and federal law isn't just important, it's critical.